appeal an application of Xanthopoulos and Rakshina.
Yes, Mr. Cayford.
May it please your ladyship, your lordships, I appear in this appeal on behalf of the appellant, Lazarus Xanthopoulos, with my learned friend, Mr. Will Tyzack, learned friend Lucy Stone, KC, with Helen Williams appears for Ms. Rakshina. There are two pupils in the bench behind, both of whom come from QEB, and one is called Jamie Moore and one is called Sophie Cullis. Lords, we agreed, I think, a timetable to try and get through the forest of paperwork with which you've been provided, and I'm sure it's been a far from pleasurable task, and to that extent I acknowledge that and apologise. It's hard to know quite who's responsible for the wealth of documentation in this case, but we're here, and subject to anything that your lordship say about the housekeeping point, then we'll have to do the best we can with what we've got. I would submit you may have different views. The timetable suggests that we should have quarter of an hour housekeeping, and then half an hour, I think it is, for each of us to make submissions about the unagreed documents. 3/4 of an hour, I'm so sorry.
We have seen a timetable, but we have given some thought to how to handle this. It depends what you mean by housekeeping.
Well, that was a word that
I have never sat on a case in this court with so many bundles in any type of case. But anyway, we're here now. It seemed to us that some of the ancillary applications might be more controversial than others. Shall we start with the application to adduce medical material, reports, stroke emails? A possible way forward is to allow you to deploy them, to admit them de bene esse, as they used to say, provisionally, and then at the end of your address we might want Ms. Stone to talk about them, or we might say we're not interested. We might reserve that issue till the final judgment, but it seemed to us there was no point making a ruling now on whether they should be formally admitted. Ms. Stone, would you be happy with that?
Yes, I would, my lord.
Right, good. That's the medicals. Now, there are at least 3, if not 4, unagreed bundles. I put to one side the very last one, which is which came in yesterday. I'm losing track, but that contains 45 pages. The last document is an open offer, which plainly we're entitled to see. The rest is what might be called your material, Mr. Cayford. Well, yes. Let's put that one to one side for the moment. That apart, we have something like 3 unagreed bundles. They're all late, they need relief from sanctions, application should have been made to the masters and so on, but we wonder whether we should simply allow each of you to refer to anything in those unagreed bundles. If it was something that was before the judge, you are in principle entitled to refer to it. If it's something that wasn't before the judge, then it might be fresh evidence. I don't know how much time either of you want to spend on this, but it is putting this last one to one side for the moment, is that pragmatic approach acceptable to both sides in respect of the unagreed?
It must be acceptable to us, yes, my lord.
Good. Right. Well, that leaves the Birch legal report and what I'll call Mr. Cayford's documents. All right. So on those, we'd better hear submissions. We don't mind very much whether we do the Birch legal and then the Cayford documents, or both together. But in either case, Mr. Cayford, over to you.
Well, I'm very much obliged. Well, I'll deal with the Birch document first, if I may. It's slightly mischaracterising the other bundle as Cayford documents, but I'm happy to take authorship if it makes it administratively more convenient. As far as Birch legal is concerned, Lord, that was originally a very, very long bundle. It comes about, as I dare say you've read, by the learned judge's refusal or decline to introduce a report from Birch Legal, from Mr. Avegni Oroshi, and it was served 8 days before the trial, or 7 days before the trial. There's a dispute about that, but it doesn't matter.
So it wasn't the 7th then?
I'm sorry?
It wasn't the 7th then?
Well, my note is that it was served on the 7th, and that the trial started on the 15th in the...
It was, when it was served on the 7th, it was anticipated the trial would start on the 13th, wasn't it?
Yes. Yes, no, certainly. But in the event, and if one's looking at it from the question of whether or not there was enough time for the parties and the court to assimilate it, there was 7 or 8 days. And it was very late. I completely accept that, have to accept that. And the previous report that wasn't before the court is dated some months before. And that's not acceptable, and it's not good practice.
When was that served on Stone's team?
Recently, very recently. In other words, it wasn't before the court at the time, and it wasn't something that played any part in the judge's decision making back in March, April.
The judge was aware of at least one of the reports and sort of had a quick look to see what you were talking about, but not you, Mr. Cayford, but the husband's lawyers were talking about and declined to admit it.
Yes.
It's probably, it may not matter, but this is really an appeal from his refusal to admit it rather than and or permission to adduce it as fresh evidence.
What it may be characterised as such, yes. So, certainly, it was there. It was available, and the learned judge decided, and correctly we would say, to have a look at it before he made any decision about admitting it, because as he said in the transcript, he said, it's going to be my aide memoir for cross-examination. And he'd rightly set himself up as being the tribunal that would deal with cross-examination in the absence of the applicant. And he purported to use that document to aid his cross-examination. And it's our complaint, of course, that he didn't do a very cogent job, and that he didn't put to the SJE all the points that might come out of the 2 reports, insofar as they differ.
But he only had one report, didn't he?
He had one report, lady, yes. He had one.
He'd been struggling then to put different bits from the other report, then, wouldn't he?
No. Sorry, I didn't mean that. I meant the SJE, Mr. Sakrov, who was the designated SJE for both parties, and he produced his report, which was the SJE report. Sir Jonathan gave permission to the husband to commission his own report many months earlier, and that's the complaint, and fair complaint, that although it was commissioned and although there's a report that does bear the date of November, That was never served. And
Why not?
Lord, I mean, there are a lot of questions like that. Why not? In other words, why on earth didn't you do this, and this?
Yes, well, why not?
And all I can say is that Mr. Xanthopoulos was suffering from a serious case of depression and psychological illness and difficulty. And insofar as a number of things that he didn't do, I can't give you any very good reason why not. I can't give you a very good reason why there isn't an open offer before the court in April of this year, March of this year, save that he went through a very bad period. And you know that he was consigned to hospital for a month in October, November 2022. You know from the papers that he attempted suicide at that time. You know that he was seen by a number of different people, because you've got the medical bundle. And it completely reduced his ability to function properly. I can't say to take advice because I don't know, I wasn't there and I don't know what the advice was, but clearly the advice would have been to comply with court orders, put in an open offer, concentrate on the issues, give full disclosure, and so on and so on. But he didn't, and he didn't for the reason I've given, the medical reason. And that unfortunately explains quite a lot of what happened, and explains also what happened in March of this year, when he applied for the nth time, about the fourth time, I think, certainly the third, for an adjournment of the final hearing. And Sir Jonathan said, no, you're not going to, the case is going to go ahead. I will make certain provision. I will delay the start date by 2 days, and I will make provision during the trial for your comfort and convenience. But I'm not going to adjourn it anymore. There's lots of reasons why not. He gives them in his judgment of the 9th of March. And it was at that point that the applicant, if I say lost the plot, that sounds vernacular and a bit casual, but he completely lost his ability to concentrate and focus and give instructions. And it was at that moment that he decided to, or he didn't decide, he was collected by some relatives of his from England and taken to Greece. At what would have been the beginning of the trial. And that's the reason why he didn't attend the trial. And you might also ask, why did he not tell the court that's what was happening, or why did not one of his family tell the court, or why did not his outgoing solicitors tell the court, if they knew? I don't know whether they knew or not. But that's another procedural aspect of this case, which is very unsatisfactory. And of course, we accept that Sir Jonathan, I'm sure with the best motives in the world, decided that on a balance of fairness, the trial should go ahead, despite the non-attendance of Mr. Xanthopoulos. And he described his function in making that decision as being somebody who would have to make sure at all costs that he gave both parties a fair trial in the husband's absence. And he purported to do that. But I don't have any better reason to give the court as to why he didn't attend the trial, save that we know that it was supposed to start on Monday. It didn't because of the order of the 9th of March. It was then supposed to start on the Wednesday. On the Thursday, we know that Mr. Xanthopoulos went to see a psychiatrist in Greece, and we've got the report about that, and that's one of the documents in the 3 documents in the what I call the fresh evidence medical bundle. And you've seen a short, well, perhaps you haven't, but anyway, there's a short report from him as to what Mr. Xanthopoulos was suffering from. We then know that he was admitted to hospital.
Mr. Cayford, forgive me for interrupting, but we seem to have strayed rather a long way from the question of the Birch legal reports. I'm sure you're going to make the points you've just been making in relation to the substance of the matter, but we'd just like to deal with the ancillaries first.
Yes. Well, I can't tell you any more about the reason that the husband's then lawyers didn't serve this report, and I know nothing of what went on between Birch Legal and the solicitors, and why that report wasn't served and didn't see the light of day.
Sorry, Mr. Cohen, to interrupt you. I thought that your application had been refined and that you weren't seeking the admission of both reports. Is that wrong?
It absolutely has, my lord. Having seen the great forest of paperwork, we thought it wouldn't help the court at all to see the earlier report, because the second report deals with the various points that we are talking about.
So it's only an application for the second report. And can you just help me, when you say the judge didn't admit it in evidence, you say he used it for the purposes of cross-examination?
Lord, yes. He
As
said,
he put it.
page 169 of the transcript bundle, and the second report dated the 28th of February.
The first report is November.
First report is the 1st of November 22, and that's at page 27 of what I call Birch bundle.
So it's page 829 of bundle 2 is the report of the 28th of February. And that's the one you're...
Yes, that's the one we want, yes.
On which page of the transcript did you say?
169.
Sorry, whereabouts on 169?
I hope that's the correct reference.
Excuse me.
Maybe it's not. What? 26. Lord, I'm very sorry. I've given you another reference, and I've only given you tells me page 26.
Internal 18.
Sorry, transcript page 26 of the bundle.
Page 26 of the bundle, internal page 18. Bottom of page 18.
Sorry, starting where?
It's the very last line where he says he's going to use it as an aid memoir.
Yeah.
Sorry, I haven't found it. Page 26 of the transcript bundle.
Yes, should be.
Yeah.
Internal page 18.
I see it, thank you.
Well, you said a moment ago the judge did the right thing in using it to put questions.
I did, yes.
Yes. Right. But it hasn't been formally admitted in evidence.
No, we submit with respect that it was wrong not to put it into evidence. The judge did the right thing in the sense that he at least looked at it, and he at least used it as he puts it, an aid memoir for cross-examination, for
Yes.
questioning rather.
Yeah.
So it's better than nothing.
Yes.
But he didn't admit the whole report.
No.
And we say he should have done,
Right.
albeit that it was late. But he'd had a week to look at it, and we're only interested in the 26 pages of the substantive report that deals with the equivalent number of pages of the Saskov report. That was the SJE. And we say he should have looked at it. I mean, bearing in mind that he did take a look at it for, as he says, for the purposes of questioning, he should have admitted it so that Mr. Oreshin could have been cross-examined if anybody wanted to.
Sorry.
The maker of the Birch report.
Could have been cross-examined by whom?
By Miss Stone. The maker of the report.
But how could the maker of a court attended the hearing when the father had the husband had gone to Greece?
No,
And his legal team had felt obliged to withdraw.
no, I take the leadership's point, of course. what could they have done if they'd admitted the report? Well, it presents a huge difficulty for us, which we acknowledge all the way through this. We acknowledge that not turning up to your own trial is a bad idea, and it's not served anybody any good in this case. And I've given your lordships and your ladyship the reasons why that is, and I can't do better than that. It's most regrettable, but it's a little artificial, one might think, for the judge to say, well, I've read it and I'm going to use it as an aide-memoire, but not admit it formally, and not, we would say, use it as a very effective aide-memoire to question Mr. Saskoff as to the merit of his report.
But how could he admit it formally when, through the husband's own decisions, for reasons I understand, and you've explained those, the witness wasn't going to be available for cross-examination?
Well, you have a good point. You have a good point. We would have preferred that it be formally admitted and that the witness be invited to attend, but that goes under the umbrella of the husband not attending with lawyers or by himself or any other how. So the answer to your question is yes, he probably couldn't. Probably Sir Jonathan had no option but to say, I can't do that because you're not attending this court. So, I mean, I have to make all these concessions, obviously, most regrettable. And indeed, if you recall any of the skeleton argument that gained the leave to appeal in this case, we make perfectly clear that none of this is satisfactory, but nevertheless, what we're complaining about and what we're appealing about is that despite all of that, and despite that might have been the husband's fault or might not have been, Sir Jonathan did not manage to effect a fair trial between the parties for the various reasons that we've set out in our note.
Yes, well, you're going to come on to that.
Yes.
At the moment, we're dealing with the self-contained application relating to Birch Legal.
Yes. Well, I'm happy to, as it were, recharacterise it as being an appeal against the refusal to include it, although
yeah.
it sounds rather better as new evidence. The court couldn't accept it back in March of 23. You've heard the reasons why. I'm not sure that I can necessarily improve on that. What we do say is that the judge, having read it as an aide-memoire, will have noticed the observations made in the Birch report about matters such as the nominee shareholding arrangement and whether or not the submissions or the observations made by Mr. Saskoff were actually correct. And that might have given him some pause to consider whether or not he should accept the SJE in its entirety. Because as a cross-examination tool, there's certainly some difference between what the two experts were saying. And Sir Jonathan didn't analyse those, we say, with any great precision, and relied effectively on Mr. Saskoff and not Mr. Oreshin. And we are unhappy that he didn't question Mr. Saskoff rather more vigorously about the concept, for example, of nominee shareholding and the entitlement to dividends, and whether or not you can have a system under Russian law whereby the owner of shares can be ignored when it comes to the question of dividends.
Right, well, let's not go too far into the merits, Mr.
No,
Caper.
very well. So,
Right.
so very well. So the point we make is that the evidence that Sir Jonathan read would have alerted him, or should have alerted him, to the possibility that what was being said by Mr. Saskoff, although not entirely different from that of Mr. Oreshin, was sufficiently different that he should question the evidence of Mr. Saskoff, and certainly the way it was put to him. In other words, that nominee shareholding arrangements in Russia were perfectly common, albeit that they had no basis in law. And on that basis, or from that basis, Sir Jonathan Cohen leapt to the conclusion that he could find that the 25% shareholding, 33% shareholding in the raft of companies that we're talking about was effectively held as a nominee by the wife in this case, and not in her own right. And we say that he must have realised, looking at the level of dividends paid to her over the 11-year period since the shares were put into her name, that this was an asset, a very significant asset, from which she benefited, and which was of considerable value. And you'll have seen in our skeleton how we say that although Sir Jonathan said, well, there's no value in these shares, and anyway, they're not matrimonial, the fact that the wife benefited to this extent from those shares means that can't be a submission, or can't be a finding that can be justified. One might think that anybody who had shares that paid an average of just over £1 million a year, averaged over the period of time, had some value. And Mr. Oreshin says that it's not something you can do. You can't just have a nominee arrangement and ignore the underlying ownership. So we say if you read Mr. Oreshin's report, it becomes clear that what's being done at the other end, in other words, at the client end of this, is that they're simply ignoring the form of Russian law. The wife is a beneficial owner, we would say, of the shares. She's received her due dividends on them, and she's entitled to count the value, at least in part, on the basis of the dividends payable onto those shares. And that's an important element. He also says that...
Oh, Mr. Cayford, really, we are deciding whether to admit this report in evidence. You could spend much of the day telling us what's in it and why it's so important. If we agree to admit it in evidence, you'll be able to do that.
Well, I'm very much obliged, and I don't want to trespass on the court's time, and I don't want to make submissions that are not appropriate to whether or not it should go in, and I take your point. I just wanted to make sure that you knew that there was some evidential value in this report that would help you in the overall question of whether or not Sir Jonathan skated over the value in these shares. We say within that report, short report, 26 pages, there is plenty of evidence that indicates that there is great value in those shares, and the judge was completely wrong to have found that there was no value to the wife in that event. So no, that's about as concisely as I can put the point.
Right, thank you very much. Yes. All right, Mr. Cayford, let's go on to the question of the latest additional bundle.
I don't know, I'm not sure. I mean, it's the bundle of Lasbo's.
Sorry, I've lost mine. They're in mitigation. There are about 12 bundles, but anyway, the appellant's additional bundle, date stamp 31st October, 46 pages.
Mr. Owen, I think a number of documents have been put into a bundle to assist us.
Ah.
I think I think that the documents that are in existence, but they've been put into. We'll find out in a moment whether I'm right.
Probably the ones that were floating around the last few days.
I think
were
yes.
put into a bundle, but I don't think it's been served on us, which is probably why I'm looking a bit blank. That it's got a name.
But it's just.
But I could be wrong.
Let's make sure that you have them all.
It was a fresh application.
Oh, apparently it has been served on us.
It has.
Thank you.
Good. Well, one loses track. But anyway, husband's updated chronology, 24th October. Husband's chronology of wife's litigation conduct, 24th October. Husband's schedule in relation to tracing and quantification of wife's true financial position, 30th October. Husband's schedule of wife's cases and her dividends received from 2012 to 20, 30th October. Husband's open offer, 31st October.
Well, I'm relieved to hear that,
Well-
Can you send it?
oh, sorry.
I'm sorry, apparently it was served, but I don't have it, so I've
Right,
never
well, we're
seen
going
it.
to rise until this is sorted out, because unless you have it, we can't really proceed further.
It's
Would
dated
help.
yesterday,
The
is it?
application was made about lunchtime yesterday.
Let us know when it's.
Thank you.
Lucy, do you have that?
No.
But I think the solicitors will have.
Your computer.
It was served yesterday.
Yeah.
Do you want us to email it?
Sorry,
Would you like us to email it?
that would be fantastic. It's l.stone@web.co.uk.
Can you copy me in as well?
Of course, of course.
Thank you, Lizzie. You got it? You've sent, okay, we have a delay while it goes through the spam filter, so.
Which schedule? Hmm. Yeah, sure. I mean, that's chronologies. Tracing schedule on Monday. And the other one.
Yeah, I'm just
Yeah.
imagination.
I'm happy to take a hard copy if someone's got a hard copy. Hard copy of it?
Hmm?
I said it because it hasn't come through. I said if there was a hard copy, I'd be happy to have a hard copy. Presented L. Dotstone, yes.
And we've got it through.
Oh, I've got it now. Got it. It's just arrived. Okay. Thank you.
No, I agree. That's
It's just the
So-
application.
yeah, I mean, still.
And George, so of course I've got it now. This one was attached, isn't it?
That's the application notice. Here we go. That's the email. There's a follow-up letter.
This one.
Sorry, just to check, is everyone ready?
No, I haven't
No,
got
okay,
it. Sorry, sorry.
You will be in a couple
Okay.
of minutes, I think.
Just let me
Sorry,
know.
just waiting. It's in a link below. Attached.
But this is the this is tracing at one stage.
Yeah.
It was called tracing at one stage.
No, but this is not limited. Okay.
Yeah. They're not producing it for today.
God, it's painful. Okay, got it. Thank you. Got it now. Thank you.
You ready?
What was?
Lord, this schedule, this bundle was served. The individual documents within this bundle, the first two, the chronologies, were served last week. The schedule in relation to tracing and quantification and the schedule of the wife's cases to her dividends was served on Monday. And the open offer was served yesterday, self-evidently, just for the record.
Right.
Similar, may I deal with the ingredients, as it were?
Yes.
The updated chronology, we are frankly quite surprised to have an issue on our hands as to whether or not we can put in a chronology. It's based on learned friend's chronology for the trial before Sir Jonathan Cohen. It's obviously very much more extensive. That chronology was about 6 pages, and this one is about 30 or 29 by the look of it. And what we've tried to do is tell a much fuller story, and for the benefit of the court. Served it last week, didn't think at the time there was going to be an issue with it. There is today. We would say that it's a document that is helpful. One can pick at it, one can identify all the relevant transactions in the case. The 6-page chronology used by learned friend at the trial is skeletal compared with ours, and not particularly helpful in terms of getting the overall picture. So I'm disappointed, I must say, that we're having to argue the admission of a chronology, but we are. So I respectfully invite the court to say that there's nothing offensive about this, and if there is anything offensive, then the learned friend can say so in due course. But it was intended to help the court. The second document is much more partisan.
Just a moment. There's a document in the core bundle. First chronology prepared by respondent wife, 6 pages. The next one, chronology of relevant events prepared by the appellant husband, not before trial judge. 18 pages, 21st of June.
Lord, yes, is your index the updated version to follow?
Yes.
Yes. Well, for the purposes of this appeal, we would cross that out as being redundant now that we've produced a fuller one. But by all, if anybody wants to refer to that, it's fine. There's a number of items, entries, obviously, that are replicated in the new one. But the new one's simply an updating chronology and an expansion as more and more documents.
Well, if insofar as it adds entries after the 21st of June, of course, nobody could possibly object, but it also expands on the 18 pages beginning at page 103.
Lord, I haven't myself performed that task. I'm sure we could. Yeah, we've identified the entries post 21st of June for that very purpose.
Right. All right. Okay. That's the chronologies. Then you're going on to the schedules.
Yes.
I think,
Well-
but we've still got this the schedule of litigation misconduct on behalf of the wife alleged.
Yes.
Which we haven't dealt with yet.
Oh, sorry. Chronology of wife's litigation conduct. Yes. Right.
That could
Yes.
just as well be called schedule. It could be called partisan schedule.
Good.
Yes.
It could be called antagonistic schedule.
Yes.
It could be called anything. It is unashamedly a trawl through the documents to see the extent to which the breaches and the litigation misconduct cuts both ways.
Yes.
And we say the point about that is that the husband was very roundly criticised by the judge at the hearing for his litigation misconduct.
Yeah.
And we say if you take a much more holistic view of both parties' conduct during the course of this trial, or this process, you will see that very much cuts both ways.
Yes. Why was this not appended to or part of your skeleton argument?
Because it was created relatively recently.
Yes. Why was it created relatively recently rather than as part of the skeleton argument?
Well, Lord, the ingredients are within the skeleton argument, but this is intended again to be a schedule of the points that we've made in the skeleton argument. It may be if somebody would go through it and say, well, that point wasn't made, I'm not sure, I don't think so. But it's possible, and of course, some of the objection is post the skeleton argument.
Could I just ask, looking at this document,
Yes.
we see, for example, now sorry, I'm just checking my notes. I don't want to. Yes, the 15th of October. You talk about the hearing in front of EVJ
Yes.
on 15th October, and then it goes on to the 20th October. What you see, what one of the things that concerns me about this document, Mr. Hayford, is it doesn't refer to the judgment that Deputy District Judge Hodson gave on the 19th of October, which is in your own unagreed bundle, where DBJ Hodson is extremely critical of the husband in relation to the obtaining of the injunction
I mean,
and the freezer.
yeah, and the freezer.
And you see, that worries me, because if you're saying that at this particular time, and I understand you are, because I've read carefully into the papers, that you're saying that the wife's behaviour, really humane and so on, was bad and amounted to litigation misconduct. But unless you feed that in also with what is happening on both sides and in the turmoil of that time, which includes a highly critical judgment in relation to the husband's behaviour in obtaining the injunction on an ex parte basis with misleading information the DDJ found. How can this be a valuable and appropriate document for us to look at?
Well, lady, if we have fallen excessively on the side of partisanship, I apologise. That wasn't the intention. The intention was effectively to set the record straight, or set the balance straight. This wasn't everybody's misconduct is contained in this document. It was really prepared in response to the suggestion that the husband had been guilty throughout of, and it was a two-way street.
Well, I absolutely understand that. But my problem is when you've got two entries, the 5th of October and the 20th of October, and there's no reference to very significant matters relating to what was going on then for the 19th of October, it's not helpful.
I have to take that criticism, lady, and I'm sure that can be replicated elsewhere in the document.
But your updated chronology, which is the first disputed document, refers to the hearing before the Deputy District Judge. And on the 21st of October, this order, the refusing order was discharged.
Yes.
First, the supplementary bundle, page 32.
Yes. Well, exactly. So there's no intention to hide anything. I think it was more a question of trying to put some documents, albeit selective, and I think I used that word myself earlier on. So I accept that, but by way of mitigation, really. But if there's something that isn't made clear in the full skeleton, well, then the criticism has some merit to it. Has some weight. I'm not saying it doesn't have weight, but it has more weight. But in no way have we intended to mislead this court in any sense at all. The lawyers in producing these documents, these were, to use the phrase in aid memoir, for the court to understand exactly what went on, and we don't hesitate from concluding. We didn't intend to hesitate from including any of the judgments or the documents or the comments. I mean, the point is that they were very amply illustrated by my learned friend at the trial, and the trial judge took all those on board, and there was a schedule, it seems, from the judgment showing 35 breaches, 15 separate occasions, as I recall, and we understand that, but some of the points that we're making in our unagreed chronology are useful, helpful, set the balance straight. We're saying that it's just not such a one-way street as would appear from the judgment and from the submissions made on the wife's behalf. So that's
Right. Those are the two chronologies. Yes. Let's go on to the two schedules, yes. 3 and 4.
Yes. Well, the schedules are prepared from the wife's documents. So your lordships have the and the ladyship have the easy to read version.
I do.
I do. My lady doesn't. If anybody.
Mr. Tyzack got a few extra in his pocket.
Yes. If anybody can contribute one more set in the large format, that
I think
would
Mr.
be very
Tyzack's
well.
got spare copies.
Yes. If you haven't written on them, Mr. Tyzack, we'd like to have one.
That's 3 or 4.
You certainly did come prepared.
You can have one spare. Does the Lord?
I have one.
You have one.
Yes.
So it's just the one.
It's the one.
Stone, you have one in legible.
I can see it on my screen.
Okay, right. Yes, right. Yes. Right.
That's all the document. Thank you very much.
So sorry, Ladyship didn't have a large copy, but so if your lordships would look at the note at the top, identification key documents in respect of grounds 3 and 5. This is the extent of the assets. Note, all information, data referenced in this schedule is from documentation before the trial judge. So this is a schedule that's been produced, and I should give credit to Moylan Jr. who did it, from documentation that was before the trial judge at the trial. And he makes a further point that the wife has produced many schedules before the trial judge. Some are at supplementary bundle section H, and some were produced during it, and we can see that from the transcript of the judgment, if it's an issue, if it's a point. The column on the left is known money received by the wife between 2012 and 2021. The second column notes on some transactions, and then the descriptions of payments in, the nature of the payments, and then the final column is comments, which are intended to be helpful and not intended to make particularly party-free points. And I could go down the column and read them all, but I was proposing to do that a bit later. But that's what this is. It's an analysis produced by Mr. Tysack of all of the payments which the wife eventually disclosed as being received by her, mainly on the question of dividends, but also other payments. You'll see the headline figures, the 3.1 million, the 5.3 million dividends, disclosed fairly late in proceedings, it must be said, but disclosed. 12.7 is the money used, the money paid by, well, the money which the wife says was paid by her mother.
Yes, all right.
But-
Don't
all right.
don't develop the merits.
I won't,
You
I
tell
won't.
us what the
Lord, I won't, but
what the
that-
documents show.
Certainly. So that's
Yeah.
what that's that. The schedule in red is again self-descriptive. What happened to the money? And the column to the right of it tries to answer that question. And the draftsman concludes that there's £4.5 million unaccounted for in terms of the money in and what we know has been spent. And then the quantification at trial, excluding any of the wife's corporate interests, concludes that effectively, if you include the 2020 dividends, which, as you will, I think, know by now, were paid to the wife and then recouped or taken back, or given back anyway, or given to the wife's father, for reasons which you
All right, Mr. Caper. What it comes to is you say that these are aid memoirs prepared by your junior 2 days ago, and Miss Stone ought to be able to cope with them, and that's that really. They're not fresh evidence, they're counsel's documents setting out things which you would be able to explain to us at much greater length.
Exactly. And the second one is the same,
Yes.
and it's the wife's case as to her dividends. And we set out there where the dividends are from, because, as you know, they're from different companies, and we arrive at approximately the same total at
Yeah.
the bottom. So that's what they are. They are documents. It's a schedule prepared from wife's documents, which we thought would be helpful to the court to see what it is that we're saying about the wife's income and her likely capital at the time of the trial.
Yes. Thank you very much, Mr. Caper. Now, we had the opportunity while inquiries were being made as to service of this recent material to discuss the application to adduce the Birch legal report, either both or just the short one. We're against Mr. Cayford on that. We will refuse leave for that. We won't give a judgment at this stage. We'll incorporate it in the final judgment. So we need not hear you on that, Stone. We'd like to hear you on the new bundle.
Thank you. My lords, my lady, can I just make one point clear in relation to Birch, the Birch report, that I'm not sure has necessarily been made clear, and of course Mr. Cayford didn't have the advantage of having been involved in the hearing, which is that the Saskov report was a single joint expert appointed by the court to deal with company law and liquidity, and he also answered questions about nomineeship. The Birch report was a report which the husband sought to put in as a valuation of what he said was my client's interests in the Russian companies. So they were entirely different sorts of reports.
Yes.
And so they weren't comparable to each other. So it's not a question if one was allowed, the other should have been allowed. Can I then turn to the small bundle? And could I go first of all to the core bundle? We apologise that these bundles are something of a mess, which may be an understatement. And the core bundle contains the majority of the documents which were put before the court when Mr. Xanthopoulos was seeking permission to appeal. And so we don't say that necessarily they were documents which should have been in the core bundle for this appeal, but rather than continue the argument and the court have no documents, as the husband wanted to put them in, we left them in. But you will see that in the core bundle, the document at 4 is the skeleton argument that was before the court. And it was indeed a skeleton. We tried to put in something that was non-controversial. The document which the husband includes, and it's noted in the index as not having been before the court, if one looks at it, it is effectively in the nature of the husband's argument in many respects. So if I could take your lordships and my lady to page 103, core bundle.
So this is just unclear, Ms. Stone. This is the identical as the coloured chronology.
No, it isn't.
Sorry,
No, it isn't. The coloured chronology is an update of this one.
This is the 18-page one.
Thank you.
Sorry. Yes.
But whereas it's called a chronology, it is in fact, in many, many aspects, simply the husband's argument. So
Yes.
let me give you an example. If you
All
look
right,
at core bundle,
we can see that, Mr. Stone.
thank you.
Yes.
Well, I was just going to look at the entry at the 22nd of November. So it is the husband's case as set out in a chronology.
Yes.
And that's what was put before the court on the permission application. And what he has done now is he has put in a yet further version of that. One could be forgiven for thinking, looking in the new bundle, that blue and red might be the parties separately, but they're both the husband. So red is what was in there from him in the one we've just looked at, and blue is his updating comments. So it's not simply anything that's happened since the original one was served, because if you look at page 3, you'll see there are comments in blue dating to the entry 21st of July 2006. Page 5, there are matters relating to 2016, and the blue comments continue throughout this document. So it's not simply an update of the one that was originally in the bundle, and we say in circumstances where both parties had put their case before the Court of Appeal in their skeletons, it is simply inappropriate for the husband to have another opportunity to put before the court these, in some cases, long arguments by him about what the judge should have known or what the judge should have taken into account. That might have been relevant before the trial judge, but not before the Court of Appeal. So we say this is simply an attempt by the husband to get further argument in this document. The same applies, but even more forcefully, in relation to the document Appellant's Schedule of Respondent's Wife's Litigation Conduct. These are arguments that no doubt he would say, if I had been before the judge, this is what I would have been arguing. But he wasn't before the judge, and we will be looking later on about why he wasn't before the judge. And so he should not, at this stage, have the opportunity to put in late, beyond late, extremely late, as he has done in every single instance in this case, documents which set out his argument, because the wife simply hasn't had an opportunity to deal with them. And so we say it's entirely unfair to the wife that a document of that nature should be before the court now. Could I then come on to the schedule at page 42? My lord, my lady, the idea that we might have had a fair opportunity to look at this is frankly risible. I'm looking at it now probably with as much knowledge of it as you, but if I look, for example, 2012, I see items there, 5 figures can be seen going into 3 of wife's Russian bank accounts for 6 months in 2012. Spent on jewellery in the UK and Russia in 6 months in 2012. Spent on designer clothes in the UK in 6 months in 2012. How on earth are my Leonard Jr. and I supposed to check the accuracy of anything of this? They may have been drawn from documents that the wife produced, but in terms of their accuracy, we simply have no idea. The intention of the schedule, as you can see, appears to be something in the nature of an audit, to say we've added up the money that the wife had coming in and we've looked at the money that she spent and we can't find 4.5 million of it. But my lord and my lady, that was not an exercise that the judge did. And so if I look, for example, now in the small box on the bottom left-hand side, what happened to the money, I see that there is a third line down, a figure which is family expenditure 2016 to 2020. Well, that figure we know because it came from schedules that we put in. And then beneath that is a figure which is just extrapolated from the information above. So annual family expenditure 4 years, 2012 to 2015, average per Wilson Wright schedules. That's not from any schedules related to 2012 to 2015. They're simply relying on the information that was there for the latter years and saying, well, we're going to assume expenditure in the earlier years was the same. So there just is no integrity to this schedule, I'm afraid, and we simply cannot, in the time available, check these very many, very detailed, in most instances very small, entries to see whether or not it's accurate. So that's our objection to that one. The next one, I think, comes from information that we provided to the court. So I can't have any objection to that. So far as the right-hand column is concerned, when disclosed, and suggesting it was disclosed by my client's brother, we don't accept that. We gave the court the figures and her brother was asked to verify them in an email, and that's what he did. So I haven't really got any objection to that page 44,
Okay,
because the information came from us.
yes.
I
Right.
don't know if I can help you beyond that.
Yeah, thank you very much. Right, we'll go and consider the second application.
We would need to redact them anyway, because they've got references to the children. Okay, well, I don't know if they didn't do the children, but I know you're entitled to them, so.
Yeah, and I've given my email address to solicitors.
Okay.
I don't know if they're waiting for to ask you or.
Okay, all right.
Richard Gitty.
And who are you from?
Chapel Youth Service, we're a syndication agency based at the courts.
Yeah, I do. Is that it's got to be anonymous.
I think the employment restrictions cover the children. I mean, the public docket, there's a practice direction.
There is. We've agreed to call them A and B in this court.
Yeah, I mean, there's a reporting restriction. There's in a previous hearing it's settled all that, so there's no issue. How long will that take?
20 minutes.
Oh, you can do it quickly, can you? If you hear with the names of the children.
Yeah.
Simply. I'm sure it's okay, unless that is a good problem. Do you mind the extension to the court minutes?
There's a reporting restriction about which I'd like to know. I know he's going to identify.
Well, there is, you can't identify from your name.
Yeah, I know. So I mean, like, whether it's in the skeleton or not, it's not going to be.
Usually you do just give the skeleton. Okay, then we follow the practice direction.
What do we have to anonymise it first?
Strongly about this.
Sorry about that. Yes, we get Jesus, won't we? Is he saying to you about the reasons for non-attendance that we don't?
Mr. Cayford, we're against you as regards document 3, even in the large format. We think Ms. Stone is right to resist your using it even as an aid memoir. It contains a great deal of detail. It was served only 2 days before the hearing, and it's unreasonable to expect her to have to deal with it. Document 4, there's no dispute. The open offer, obviously, there's no dispute. It can be referred to. As to the blue amendments to the chronology, that is document 1, and particularly document 2, the schedule of litigation conduct, we won't stop you referring to them as part, they are essentially part of your argument, particularly document 2. As I say, we won't stop you referring to them in the course of your argument. Now we can get the substantive show on the road. We would ask you, Mr. Cayford, please to aim to sit down at 3:45 this afternoon, which will give Miss Stone half an hour, and then obviously we'll continue tomorrow, and you will no doubt wish briefly to reply to whatever she says. Right, thank you very much.
Very much, Bryce. So do we throw away the previous schedule?
Well, I think your previous schedule had us spending the whole of this morning on the ancillaries.
We did. And we've only spent half of it.
Yes.
Lord, I'm aware that the Lordships will have read some of the voluminous bundles, and obviously I don't know how much you've been able to read in the time that you've had, and given what you've got, and given the apparent absurdity of some of the documents in those bundles. In other words, is there really any point in reading a several hundred-page exhibit to an affidavit or to a report that's in Russian? The answer is probably not. Is it reasonable to expect your Lordships and your Ladyship to have read the transcripts, which don't run to 271 pages, they run to about 1,000 pages, or just over 1,000 pages, by the time you realise that each page contains 4 pages? And again, I'm sure the answer to that is no. So during the course of our submissions, we'll draw attention to perhaps 1 or 2 of the references in there. Lords, I don't know the extent, again, that I would need to open some of this to you, as it were, how much of the background you've read, and whether or not I need to go into a little bit of that as part of the context of the case.
I would have thought not, Mr. Cayford. I mean, you and Ms. Stone have both been in the game a long time, and you don't need advice. How you use the time, it is very much up to you.
Very well. Well, I'm very much obliged, Lord. You have the history of the parties' relationship and their marriage. You have some element of disagreement between them, but that may not matter for the purposes of this case. What does matter is, at the very least, this was a 15-year marriage between the parties, which in these courts is usually considered to be a long and substantial marriage. You know that there are two children who we're calling A and B and not identifying in any sense at all. And you will have seen, I hope, the very unfortunate circumstances under which child B was removed from this country by the mother. And if I need to go to that, I will. But that's something that played an important part in the husband's attitude to these whole proceedings and his psychological condition, which indeed was recognised by Sir Jonathan Cohen, albeit briefly, in his judgment. Child A appears to be still living in this country and is still going to a well-known girls' school in London. And the intention seems to be that she's going to stay here for her A-levels and may or may not stay in this country for university as well. She's currently living in what we call the matrimonial home, the former matrimonial home. Of course, that's contentious as to whether it is a matrimonial home. But she's apparently there with a third party, with a nanny or some carer of some sort. Although sadly the relationship between her and her father has broken down, at least for the time being. And it's also right to note that the father would say, husband would say that he had a very good relationship with the younger child until she was removed in that way. But that has now also suffered the disadvantage of absence and hostile parents. And so that relationship doesn't appear to be in good shape either. Although one of the points we made in our skeleton is that in terms of the husband's ability to finance himself, it ought to be reasonable for him to expect to travel to Russia from time to time for the purposes of contact. And that's something which we say is very challenged by the level of order the judge made. My Lord's Ladyship, habitual residence and the connection that either or both parties have with this country is relevant in both ways, in a number of ways, I should say. The wife is now arguing that the husband's links to the UK are weak, and she's rather changed her tune about his intended long-term residence. In the Russian proceedings, she was saying that he was a resident of Russia, and that was one of the points she made in aid of her petition to the Russian courts. Now, she says, and we say with a certain amount of cynicism, it suits her to do so, that he does not intend to live in this country, he intends to live in Greece. And you may have picked up from the chronology that she's changed her tune about that, having originally said it's a Russian family, he's going to want to live in Russia, these proceedings should be in Russia, they don't need to be in the UK. But the husband has made it very clear on a number of different levels, in a number of different ways, that his intention, if he's able to, from this court, to stay in this country and to try and make something financially of what is left to him at the end of this marriage. In terms of the connection with this country, it is undeniable that it was back in 2011 that the parties first came to this country for the purposes of education, and that they've been here. There was a gap, I think, between 2013 and 2016, but there's been a continuity of education in this country from, as far as the elder girl is concerned, from 2016 to date, and as far as the younger girl is concerned, from 2016 to the date that she was removed, contrary to an order made by my Lord Justice Moylan, and contrary to an email confirming an earlier order by Sir Jonathan Cohen that she should not be taken out of the country pending the outcome of the husband's appeal against the Children Act order. I referred to that earlier on this morning.
Yes.
it's entirely reasonable, we say, that the husband would think of and treat the flat in Edgerton Garden, Ennismore Gardens, as the matrimonial home. Although there's a live issue between the parties as to whether they were a Russian family living in Barnwell or whether they were here. The fact is that they were here from 2016. The fact is they bought a very nice flat in Ennismore Gardens. The fact is they lived there throughout the term times at the very least, from that moment until relatively recently. And it is hard for the wife, we say, to gainsay the husband's case, but that was what he wanted to do. It was based on children's interests, but he went along with that. He was happy to do that. It was his idea as much as hers. And it's only recently, following the breakdown of the marriage, that the wife has gone back to Barnwell. We don't know how often she comes here, because again, the relationship between the parties is not good. And he says, as part of his offer of today, that he would like, if it were the court's wish, and if the court was inclined to make an order that, as it were, deals with this case once and for all, to have the Knightsbridge flat as his London property. May I just make an observation, or may I, as it were, float this to the court? We're well aware of the costs of this case. It may be that it's not the most expensive matrimonial financial remedy case yet heard by this court. And I say that only because I understand that the matter in the Supreme Court at the moment might surpass it for extraordinary fees. But there's no gainsaying that the level of fees in this case is absolutely extraordinary. A number of judges have commented on it, and it's not something that we advance to this court with any degree of pride or pleasure. Clearly, something's gone horribly wrong. It may not help you for us to go into why that is, but one of the points that we would seek to make, albeit without our conduct chronology, as I called it, but the second document that you will not allow to be admitted to this court, is that there have been.
Sorry, we are allowing that in.
The
So
second chronology.
Yes, it's only your
So sorry,
Mr. Tysack's hard work that has been excluded.
He did some hard work on a number of documents. He having had the advantage of being in the case for quite some time. The point I'm making, Lords, is that the level of costs is absurd. Whether this court is interested in exploring or saying anything at any stage of these proceedings about the use of LASPO funds, about the LASPO order principle that has enabled the costs in this case to be so high, is obviously a matter for your lordships. It's not part of my appeal, but what we do and what we're intending to say about this is that the court has permitted expenditure by the husband, paid for by the wife, as a result of the LASPO orders. And whilst no doubt a number of people can wring their hands in disapproval, the fact is that without the LASPO orders, the husband wouldn't have been able to have got this far, wouldn't have been able to incur the money that he has spent. And as we pointed out in the skeleton, his costs of the financial remedy proceedings are probably about 45% of the total spent, and the wife's costs are about 55% if one factors in the incidence of VAT. And so it's regrettable whether this court is at all interested in going to that part of our practice and procedure is matter for the court. Maybe not, but where there's been a huge amount of criticism and complaint from some of the judges who've heard the proceedings thus far, All I'd say on behalf of the husband is that he's been allowed to do that. He would say, if one looks at this document, that he's been responding to applications, he's made his own applications. It's been an unchecked procession of litigation, which is unattractive. And I'm sure this court finds it as unattractive as some of the lower courts did as well. There it is. We think that that there are as many breaches committed by the wife thus far as by the husband. It doesn't in any way gainsay the finding of Sir Jonathan Cohen based on schedules produced by Miss Williams during the trial. But if we're right about that, we would say that 17 breaches of order by the wife in these proceedings, and that comes with consequences.
Are the frequent changes of legal advisors relevant to how the total came to be what it is?
Yes, they are. Of course they are. But the problem that the husband had is that he has managed to overspend, if that's the right word, and I put that in bracket, in inverted commas if I might. He's spent more than the LASPO costs budget that was offered to the relevant court on each occasion, to the point that he's now in debt to those solicitors. Hard to tell. The figure that Sir Jonathan used was £900,000, that he's unpaid fees. Whether in fact some of those solicitors are going to take proceedings is an unknown question, and it's certainly something which Mr. Xanthopoulos is investigating. In other words, some of the solicitors may feel that they don't want to pursue those fees. They may feel that the observations of Sir Jonathan that he wouldn't allow those fees on some kind of assessment would be sufficient to put them off. On the other hand, some of them might feel that they're going to go on anyway. So at the moment, that's work in progress. And Mr. Xanthopoulos obviously is keen to get his bill down as much as possible. And he's got a very valid argument about that. But the difficulty identified on each occasion has been that, I think even Moylan Friend's side has been saying that it's going to cost about £50,000 each time there's a change of solicitors to read into the case and get ready. And that, with 7 firms of solicitors, you can see how that adds up.
Mm.
But the reason...
But looking at the list of the names of the solicitors who he's moved on from, if I might put it like that,
Yes.
they're all highly specialised professional financial remedies solicitors.
Indeed.
And the reality is that he's fallen out with them.
Well, milady, I'm not sure you can infer that. The fact is he's fallen out with them because he can't pay their fees. But I think it would be wrong and it would be unfair on the husband to assume that he's fallen out with them for reasons other than his non-payment of the bills. And so they've been funded under the LASPO orders. And you saw with one of them, Tillingham K, they were owed £51,000 at one stage and threatened to come off the record for that reason. And following another hearing, they kissed and made up. And they continued to act for him for some time. But each one of them has ended up substantially out of pocket. And the LASPO orders haven't covered all of the overspend. And so whether or not that is something which would be relevant on an assessment, were the costs paid to go for an assessment, and indeed were the costs paid the costs paid to go for an assessment before Sir Jonathan Cohen, if he set himself up in that particular regard, whether or not he would disallow all of those costs that have been in excess of the budget, we don't know. And we said in the skeleton that there's been a couple of articles about that in the legal press, and whether or not solicitors who set themselves a budget but inevitably or can't prevent themselves from going over, whether they should be entitled to claim more. And I'm sure that the profession, I think, doesn't know what the likely outcome would be, were this to be something that were litigated. because the different views expressed by different people. Of course, on the one hand, you've got the solicitor saying, I did the work, I want to be paid. And you've got the view tentatively expressed by Sir Jonathan, which is that they shouldn't be going over the budget, and we're not going to allow it on taxation. But the point is that it's not right to assume. I don't know myself, and I can't give evidence about it even if I did know. But it would not be right to assume that he's fallen out by reason of his litigation conduct or by reason of the difficulties that he's presented for those solicitors. We simply don't know.
We have the overall figures for costs, but are there any schedules? Well, I mean, there should have been Form H's for the trial below. Were there any schedules produced showing how the costs have been, probably not on your side, but were there any schedules at all, do you know?
Below or thus far?
Below.
Below. I'm sure there were, I'm sure. Is there some schedules? I'm sure there were schedules all the way along. I don't think anybody's been accused of not producing cost schedules.
You would have had to produce schedules to get the order prospectively, but I wonder whether there was a schedule of incurred costs.
Well, not that I've seen, but I'm sure, again, I'm sure there must be.
Oh, there are schedules, I'm sorry to interrupt,
Please,
but
please.
there were schedules of the overall spending, so the court could see how much had been spent overall by which party on which aspects of the case. There were schedules showing how much the husband had spent with each firm of solicitors and where he had overspent with each firm of solicitors. So there were several schedules put before the court in
Which
the first
were
instance. We can
prepared
certainly,
by your side.
yes. That obviously disclosed to Mr. Xanthopoulos by email, although he wasn't participating.
Yes.
Well, I suppose those would be accessible. I suppose my lay client would have those if the court wanted to see them, or a learned friend can produce them herself. I don't have them myself here. But the figures, I'm aware that the figures were known, the figures of the overspend, the figures of the claim that the solicitors had against Mr. Xanthopoulos on each occasion, and they varied. And some were higher than others, obviously. Some solicitors lasted the course longer than others, and ran up bigger bills.
One of the reasons I was asking is because the cost figure is put forward as financial remedy and jurisdiction.
Lord, yes, the overall cost figure is
So
yes.
at the moment, speaking for myself, it's not clear what part of the figure was in fact financial remedy and what part was jurisdiction.
Again, I'm sure we could. Well, I'm not sure actually. We could try and produce that figure.
Don't worry, we just don't know.
No. I mean, as far as jurisdiction is concerned, your lordships may know a fair bit about the previous goings on, and your lordship, in fact, yourself, Lord Justice Moylan, made the observation during the course of one of the hearings that that the wife had obtained her divorce in Russia in breach of her main injunction. And you made that observation. It's on our chronology. I can point you to it if you like. But what was said, certainly by the wife in Russia, was such as to provoke a spew of litigation in Russia. And as you know, she ended up obtaining her divorce in Russia, contrary to the humane injunction in this country. And the parties agreed eventually that the husband would recognise the Russian divorce on the basis that he could have his Part 3 hearing in this country. And that was an agreement the parties came to. I suppose a small outburst of moderation. In other ways, immoderate case. But I mean, Lords, if I can give you a flavour of quite how all of this went wrong right from the very beginning. looking at the document that we just referred to, the wife filed her request in Russia to ask whether or not the husband had petitioned in London on the 2nd of October. On the 2nd of October, at about 7 o'clock, she was served with the husband's English petition. She knew that. She knew that. A week later, nearly 2 weeks later actually, she first filed for divorce in Russia. And she told the Russian court, firstly, that there's no dispute over the division of jointly owned property. Secondly, that the husband consented to the dissolution of the marriage. Thirdly, that appended to the petition is a receipt to confirm that copies of the statement of claim and appended documents that the respondent does not possess have been sent to him. Fourthly, and this one is true, marital relations between the claimant and the respondent ceased from the 27th of July 2020. That's true, whereas the first three assertions were not. And fifthly, of those assertions, there's no dispute over the children, all of which are completely untrue. She told, or her counsel told, Deputy District Judge Hodgson on the 15th of October that she was going to commence proceedings in Russia. This was 2 days after she had commenced proceedings in Russia. On the 6th of November, she presented a second petition in Russia because the first court in Russia had returned her petition. And so she petitioned again in a different court. And said, again, a number of other things. She said, firstly, that the marriage had broken down irretrievably. That's not in dispute. She made the point, interestingly enough, that the respondent is habitually resident in London. The children of the claimant and the respondent attend educational institutions in Barnwell, and in particular, since 2017, the elder daughter attends the Municipal Budgetary General Education Institute. And of course, we know that she's at the well-known London Girls' School, although she might go to extra classes during the holidays. Despite the fact the spouses visit London, the United Kingdom from time to time and sometimes live there, the Russian Federation is the actual and habitual place of residence. And as stated above, the spouses' children permanently live and learn in Barnwell. So that's what she was saying in Russia. And it was on the basis of those representations that she got her divorce in Russia. And I recite that to you to make the point that it all went very wrong very, very early on. And it would be quite wrong to say that the husband's litigation conduct at that stage was in any way the subject of criticism, because he realized very quickly that he had a big jurisdiction fight on his hands that was being fueled by misrepresentations by his wife in Russia. And so, in answer to Lord Justice Moylan's question, there was a great deal of money spent in Russia that we say simply not the husband's fault, and it was contentious litigation. And it won't surprise you to know that there were a number of child hearings as well in Russia, and they continue to be. And it's been a very unhappy saga. It brings me back, if you like, to the wife's conduct in removing the younger daughter to Russia on the 18th of May, in breach of an order of Lord Justice Moylan, Sir Jonathan.
18th May, which year?
22, Lord.
Thank you.
22. It's in the section, page 8 of this document, under children's proceedings. "17th of May, Lord Justice Moylan stayed paragraph 3 of the children order, pending determination to ensure that children were not removed from the jurisdiction as husband's unagreed bundle 887. Sir Jonathan Cohen, who was in the habit of emailing the parties on a fairly regular basis, emailed on the following day, suggesting that the girl shouldn't return to school in London and restore contract. The solicitors acting for the wife told those acting for the husband at the time that they'd been in touch with their client, who was somewhere in the English countryside and just taking a couple of days away from London. But didn't indicate at any stage that she had the intention of removing the child in those circumstances. The husband got wind of, he was suspicious, he didn't think that what he was being told was likely to be true. He obtained a court alert order from Mrs. Justice Morgan on the 19th of May, which turned out to be too late, because according to the wife herself, she left England on the 18th with the child. And in answer to the question, how did she manage to do that, bearing in mind that the passports were with the husband, she said that she was able to get alternative travel documents, I think from the Russian embassy, but certainly from some other source in this country. And that's what she used to flee the country. We say that's a very, very serious piece of litigation misconduct. And as I indicated to your lordships this morning, that had a profound effect on the husband, who felt that he was very much on the back foot at that stage throughout these proceedings. He was the one who was going as supplicant, cap in hand, to the court on occasion after occasion to, as it were, see off all of these applications and to see off a very determined wife and mother who he suspected wanted to take the child away. He would say that his relationship with the child was extremely good and that the child had said that she wanted to stay in this country, for what it's worth. But he realized that he had some work to do, and that's what happened. And the child hasn't been back in this country since. And it's very, very sad. But as an example of the litigation conduct that you will find in this document, that's one of the most egregious and disappointing. Whilst I'm on the subject, whilst I've got the document in my hand, we say, and I'll just run through these very quickly if I might, we'll say that on the 20th of November, the wife's lawyer, in breach of Mr. Justice Holman's order, ordered her not to take any further steps in Russia. She filed documents at court number 8 in Barnell. The wife subsequently asserts that she's not aware of the breach until 8 days later. Well, possibly.
Sorry, where are we looking?
We're looking at 20th of November 2020.
Thank you.
Lady, I was just going to take you very quickly through the items in red. On the 2nd of December 2020, she, having agreed or having been given an undertaking to Mr. Justice Holman that she wouldn't take any further steps in respect to the Russian proceedings, she didn't apply for a stay. She emailed a copy of Deputy High Court Judge Cusworth's order to the court, to draw the court's attention to the fact that she didn't agree with the jurisdiction being assumed by the English court and the disputed items of the order. She said consideration of the issue is expected in May, and it is our evidence in our case that the husband's Russian lawyers confirmed that the court file only had the unsigned copy of the covering letter and no application for a stay was ever made. So we say there is another clear example of a breach of this court's order. Ditto on the 17th of December, when further hearing in the Russian courts, despite Justice Holman's order, and the wife making it clear that she didn't agree with the main injunction. She got her divorce on the 11th of March of 2021. And there's your lordship, Lord Justice Moylan, in the case that was reported as Re-Ex 2022 EWCA 1167. I'd also note the wife obtained the divorce in Russia despite the English court having made an order prohibiting her from taking any further steps in those proceedings and requiring her to seek a stay. Again, or rather overwhelming for a husband who's having to beg his wife for money to resist applications like this. 21st of October, the undertaking given to Deputy District Judge Hodson to give 95 days notice in writing of any intended withdrawals and transfers. On the 15th of October,
Just before we leave 21st of October 2020, the freezing order was discharged.
yes,
And that was what, from material non-disclosure?
it was discharged on an undertaking apart from anything else. But yes, it's true that Deputy District Judge Hodson was rude about the process.
Like you said, it was
and-
misleading and that hadn't been full disclosure and there was no need to have an ex parte hearing.
He did.
And the 95 days was he accepted the undertaking of 95 days because that was the notice that had to be given on the account in question in any event.
Exactly. Yeah, I don't seek to go behind that at all, and you're absolutely right. And it's if you like the old way of getting freezing injunctions.
Not by October 20.
Not
I
by
hope.
October. It was supposedly dead by 2014 with BL and UK, but the husband obviously hadn't read that case and or his lawyers, and that's what they did. And it's regrettable. It's not good practice. We're not saying it is. You can see why it happened, and you can see also how it spawns an argument, and you can see you've probably seen what the wife says about it. It doesn't take us very far, but I'm addressing in a way the stigma that might attach to this husband by the comments of Sir Jonathan Cohen in his judgment, and the way he's been portrayed as somebody who breaches orders left, right, and centre willy-nilly, and somebody who's able to push costs up, in this case, without regard to the cost, which clearly isn't the case as far as he's concerned, because he has to beg every time he wants some money to either bring an application or resist an application. And he's ended up at the end of it all, perhaps 900,000, perhaps half that. I don't know the correct figure, but he's ended up in serious deficit to his solicitors. And one can see how it can happen, and one should not, as I have submitted already, that one should not necessarily blame him for how that comes about. Just to complete this, Lord, April 21, and this is another problem that occurred all the way through. The wife failed to pay the LASPO payments on time on a regular basis. So that in itself is a breach of the LASPO order. The first one we've recorded is the 1st of April 2021. The second one was the 1st of May 2021. This of course meant that Mr. Xanthopoulos' day-to-day maintenance was prejudiced, but also his ability to pay lawyers, more to the point, was seriously prejudiced, and they didn't like having to wait, obviously. So there's two in the spring of 2021. There's a further breach on the 1st of June 2021, when she failed to pay the £150,000 due on that date. And she also failed to pay the rent that had been ordered 6 months in advance on that date. There was a third-party debt order in front of Mr. Justice Moore on the 8th of June 2021, at which the wife's team didn't attend at all, despite having been given notice. And Moore J thought it right to record the following. It's recorded that the judge expressed immense dissatisfaction about the way in which these proceedings have been conducted, and expects the respondent, that's the wife, to pay the monies that were due on the 1st of June, no later than 4 p.m. on the 11th of June. So again, it just gives you, and I hope gives this court a slight flavour, that the litigation conduct argument was a two-way street, not a one-way street. and I don't put it any higher than that, but it's interesting and significant. Lords, my lady, you've got similar points throughout 21-22. 1st of September, 1st of October, 1st of January 22, 1st of February 22, 1st of March 22, 2nd of March 22, all breaches of the orders to pay maintenance. There's a small, less significant non-compliance with Mr. Justice Mostyn's order about moving money without an explanation from the Coots 95-day account. Don't need to dwell on that. The next breach in our chronology is the one I've already taken you to, about the removal of the younger child from this country. That's the clearest breach of my Lord Justice Moylan's order. And the court application sadly too late. And there it is. So I think that was a very long answer to a question that Justice Moylan asked me about knowing the cost of the jurisdiction questions as opposed to the financial questions. And you can see that most of the Russian expenditure related to jurisdiction, but also the husband had to fight in this country for his right to, if not petition, to bring his Part 3 application. And as you know, that's been resisted all the way along the line anyway. And it was only later that the parties agreed that he could bring the application. And that's what ended up here in front of Sir Jonathan Cohen. Lords, I hope I've covered adequately, or as well as I can, the husband's failure to turn up to this trial.
You've, if I can put it delicately, given evidence about that none of that was before the judge, was it?
Well, my lord, in a way, some of it was because the husband had been making applications since the previous November for an adjournment
Yes.
of the main hearing, and he cited his mental health on most of those occasions. And well, I hear what my own friend says about that in due course, but it's our case that the applications to Sir Jonathan Cohen, certainly on the 7th and the 9th of March, were based on his mental health issues.
But the judge refused to adjourn the trial altogether, although he pushed it back a couple of days. There was no application to this court to overturn him.
No, there wasn't, and not only that, there was a bit of self-help after that, which is, I've already, as it were, acknowledged, is a big difficulty in my case, because you can't expect a court simply to adjourn. Normally, you can't expect a court simply to adjourn of its own motion merely because the parties don't turn up. But what we do say is that there was very considerable mitigation, not only at the time, not only with the psychological reports that were before the judge, and they're in the bundle. So he knew that there was an issue, he knew that there was a condition of either serious or moderate depression, but a serious mental illness is the way the psychiatrist described it. He knew that was the case. He had Mr. Xanthopoulos telling him that himself, that he really wasn't up to this and he was feeling dreadful, etc., etc. You had Dr. Minus-Wallace saying that he probably wasn't able to do this and this, and I realise that's been subject to some comment by the court.
Yeah.
But that was an issue. So it wasn't as if he wasn't aware that there was an issue bubbling around in the background that the husband felt very strongly about, and was the basis, I think this court can accept, of him asking that the trial itself be put over to a later date.
Yes, all right, but it wasn't, and there we are on the 15th, and counsel and solicitors for the wife walk out, in lay people's language. What do you say the judge did wrong after that?
It's hard to criticise the judge for what he said and what he did, in the sense that he said, that being the case, my having done my best to accommodate this litigant, I will have to give him a fair trial, and I will have to read the documents and be the cross-examiner, putting to the witnesses the points that he would have made were he be there, as best I can ascertain those points. So he said all of that in the transcript. I think what we're not so happy about is that he could, and we say in the circumstances should, have adjourned the trial, because he would have known that there was a serious medical issue behind the husband's non-attendance. I appreciate it might be a contentious submission to make to this court, because this court might think he had lawyers.
Should have adjourned the previous week or should have adjourned on the day?
Lord, it would have to be on the day.
Yes.
Although he was very unhappy that the court didn't adjourn the week before. So that's our principal point of complaint.
You didn't appeal.
Sorry?
But you didn't appeal, and he was
No, I know.
he was lawyered up.
I know. Lady, I know that, and it's a problem for us. I completely accept that. He was lawyered up, as you say, and clearly things were going on behind the scenes that, of which the judge was made only partly aware. And I'd go further and say that he would have had family and friends who could have done something sensible, like tell the court what had happened. And we completely have to accept that that they didn't do that.
But you're saying that on the morning of the trial, when your lay client simply didn't come, I know the reasons you say he didn't come, but from a judge's point of view, and therefore from looking at it as an appeal court, when he simply didn't come, but his legal team, his new legal team, felt obliged to withdraw, saying that, amongst other things, there was a position statement that had been prepared, but your lay client had not given them permission to file it, that the judge should have said, "Oh, we better adjourn." That's your case.
Well, I mean, lady, it has to be my case, unless we say no, he should have carried on. But in the expectation that your ladyship might think that he probably should have carried on and was right to carry on, then our fallback submission is that he should have addressed the case and he should have addressed the issues more fairly to the husband, and granted the husband more, well, approach the whole question of the assets, and that gets me into the other points of our appeal. That he should have addressed the question of the assets and what was available for distribution in this case in a much fairer way than he did. I can only take the non-attendance point so far. Obviously, with the wisdom of hindsight, or even without the wisdom of hindsight, he should have asked a friend to tell the court that he couldn't come because he'd been taken back to Greece, as he tells us.
Yes.
And that he was taken to hospital on the second day of the hearing, as he tells us, and he saw a psychiatrist, and that he was admitted to hospital in Greece a few days later.
Well, whether that's correct or not, and we're still looking at it from the point of view of the judge.
Yes.
Speaking for myself, I wonder whether the judge was actually under any obligation to do any cross-examining. I mean, he could obviously he had to decide the case on the material before him, so he has written evidence filed by the wife, written evidence filed by husband. He would have been entitled, wouldn't he, to say to Miss Stone, well, is there anything you want to add? Otherwise, I'm going to go away and think about it and write a judgment.
without hearing evidence.
Hmm. Well, without hearing oral evidence.
Well, he'd have been probably obliged to hear the evidence that Miss Stone wanted to put before him, be it written or be it oral, so that he could make a decision on the facts of the case. Would accept that. But he could certainly say, well, I don't need to hear from this witness if there's not going to be any cross-examination. I'll take this witness's statement as being read, and in the absence of any reason why not, as true. Because he could have done that. Yeah.
Well, you are certainly entitled to say that the awards he made were inadequate. So you're not shut out from saying that by the fact that the client didn't turn up. So
No, well, that
Right.
and that's, as it were, leads me on to that next point.
Yeah.
Um, Lords, the point we make about the level of the order, and it's, I hope, reasonably clearly set out in the skeleton, is that after a 15-year marriage, 2 children, a wife who, credit to her, if credit be due, has worked very hard during the course of the marriage and has provided the wherewithal for most of the family expenditure. It's clear that the husband earned a bit, but in relative terms, very little. And so she's been the breadwinner. It is, in some ways, a role reversal. I can see that some might kick against that. A conventional role reversal, and Lord, I know it's not a very attractive way to put it. I don't really mean it in the way that there's a conventional pattern that dictates these events, but there is often one party who makes the money and one party who stays at home makes a contribution. And that's all been dealt with in previous House of Lords and Supreme Court authority. There was an issue between the parties as to the extent of the contribution made by this husband. And of course, the wife denigrates him throughout her evidence, says that he did really very little, says that his interest in working, be it for a family company, be it for anybody else's company, was minimal. He lounged around much of the day. He wasn't interested. And she says that his contribution to the maintenance of the children was minimal. He wasn't able to he didn't go to court to give his contradictory evidence about that. He disputes it vigorously in his various statements. He says he made a very significant contribution. And you may have picked up from part of the chronology, I don't know how much of it you've read, but that when the parties went to live in London, we would say full time, he was the one who was there with the children full time, and the wife, after a little while, went back to Russia and carried on working from Russia, and that she would come over from time to time and the children would go out to Russia during the holidays.
Sorry, Mr. Cayford, but I'm just wondering where this is going, given the judge's finding at paragraph 109 that he was prepared to accept that he should treat the contributions towards the children as equal, albeit assisted by staff. Are you saying he was wrong, or that wasn't a proper finding on his part? I mean, what
No.
finding would you have wanted?
No, I would have wanted that finding. Perhaps I'm
So you got the finding you wanted without
yes,
him
well,
being.
exactly. Well, let me embrace it. Let me keep it.
yes,
There's just a feeling from that and from the way the case is put that this was not a full contributing husband. That his contribution to the children, in terms of his hands-on day-to-day care, was.
That's not the finding the judge made. The
No.
fact that I perfectly accept and understand that your lay client may have felt underestimated, distressed, cross about the way the case was put in relation to his contribution towards the children. But the fact remains that what we have is a judgment where the judge didn't find that to be the case. He found that their contribution was equal.
Lady, let me leave that point right there, and say that that being the case, and as it were, threading that back into the equal contribution cases and all the dicta from White et sec, then you've got a situation where this husband would have had reasonable expectations of some form of capital sharing of the money that was generated during the course of the marriage, and some form of ongoing provision, subject to his ability and the court's believing that he should earn a substantial living himself going forwards. And so as far as the money is concerned, that takes us to a schedule which I think you don't like. But on the basis, no, you do like the schedule, you do like the second schedule.
Dividend
The
schedule.
dividend schedule
The
is fine.
dividend schedule. The dividend schedule which shows, or would if I could find it. The amount of money coming in to. Could I ask you to look at it, please, briefly? The amount of money received by the wife on her case as to dividends is a total of 17,163,000. And those are declared dividends. The parties didn't spend all of that, but whatever it was, it can't be said that, as I think is being suggested, that those were unearned income or non-marital assets or a non-marital contribution to the party's finances by reason of the fact that the shares were given to her, it is said, by her father. And we'd ask you to very much bear in mind that this lady's been working for the company in one shape or form since 2006, that it may very well suit their argument and their purposes to suggest that the shares were a gift without consideration from the father. And it may be that they do say that the financial controller of the company is not what it means in this country, that it's a much more menial task than we would understand an FCO within English corporate law. But the fact is that she has been FCO since 2008. She has been working in this company. It's said by all, said by her brother, said by her, that she works very hard in this company. This company, we know, is generative of massive dividends and massive profits. That much is clear from the report that is in evidence, and clearly has been able to, by definition, but is able to pay the substantial dividends that you see here. And we say it's perfectly plain that those come from her contribution to the company, her work within the company. It's true that the salary element of her remuneration is much less, and the judge did make that point. But her overall package from her employment with the company is very significant, and you see it in this schedule. And it's no different, we would say, that from a mother, a stay-at-home mother, contributing to the children and doing everything of equal value, to the husband producing dividend income of this size that should be taken into account as an overall money earned during the course of the marriage. So it's a question of whether you would accept what's been said against me, that because the shares were given to her by her father, and I can't dispute that that is the case, but for no consideration, well, we do contest that, because she's been given shares as a valued employee of the company, member of the family, same shares as her mother, who doesn't do nearly so much work, but shares which produce very significant dividend benefit to all of them. And even on the Sakharov report, if the parties, if the directors, the shareholders sit around in their board meetings and decide they're going to pay themselves a certain amount of dividend income, they can do that. That's what they've done in this case. The wife's got 25% of what's been paid out. And maybe that the other two men in the company pay themselves more. We don't know, but we assume probably they pay themselves a great deal more by way of salary or other bonuses, and that seems to be suggested by the reports. But it doesn't gainsay the fact that the shareholding in this company, which the wife is intimately connected with, is generating this amount of money in dividends. And it's wholly artificial for the learned judge to say there is no value in this company or there's no benefit in this company that can be in any way taken into account in the asset schedule or the funds available, assets available to the parties going forwards or now because they're not marital. We say that's one of the fundamental flaws of the judgment. He very quickly dismissed the whole idea that this could be marital and capable of sharing. And we say certainly not. In fact, for the judge to have got to that conclusion, he's had to accept the evidence of the wife's brother that basically the men do all the work in Russia, and the men are all powerful, and it's a boys' club, and women are not regarded in the same way. And that doesn't survive the analysis by either of the Sakharov doesn't even survive the analysis of Sakharov.
But we're talking about two different things, but correct me if I'm wrong, because Mr. Sakharov was talking about the legal position on the ground under Russian law as far as companies are concerned.
Mm-hmm.
And what the judge found as a fact, having heard oral evidence, was that basically notwithstanding what the strictly legal position would be in Russia in relation to a company and these shares, the reality was within this family that's how things operated. And that was a finding of fact he made, having heard evidence.
Lady, yes, except that what he's not, as it were, taking into account is that before the £7 million in 2020 was mysteriously taken back by.
Well, again, we've got a finding of fact about that. The judge accepted.
Well,
we can't go behind his findings of fact.
no, but what you can do is you can note that until that particular event, you note the judge's suspicion, and of course that doesn't help me because the judge indicated that he would be very suspicious were it any other case. But having heard the brother, he thought probably he didn't need to be suspicious. We accept that's the judge's finding, and to that extent we have to accept it. But we say, looking at this objectively, and looking at the timeline, it's a very curious finding to have made, but it doesn't gainsay the fact that even apart from that, she'd received about £10 million in dividends.
10, 7, 9, 9, 5.
Yeah, nine and a half.
Yes, thank you. Yes.
£9.5 million in dividends over a 8-year period.
Mm-hmm.
And of course, it's no coincidence we say that the dividends have rather dried up during the course of these proceedings. And the cynic would say they'll probably resume service when this is all over. But
doesn't that depend on whether the return? Oh, I see. She didn't return the shares to her father, just the dividend.
Yeah.
yes,
Right. I see.
yes. And whether it's a matter of law, under Russian law, that's permissible anyway, is a bit of a question. And what we say, notwithstanding Mr. Sakharov, the payment of a dividend, which is the function of the governing body having decided to pay itself dividends, the shareholders having decided to pay themselves dividends, the dividends paid, the dividends are and always were, but certainly become the property of the recipient. And if a request is made by one of the other shareholders to pay back, in inverted commas, the dividend, it's nevertheless a conscious choice of the shareholder to make that payment. As a matter of law, the shareholder doesn't have to make that payment. And this may be, without being cynical, this may be an arrangement within the family whereby if it is thought that the family does need it, or that there's some other reason for giving it back. My point is, it's not giving it back. It's actually a proactive gift of the money from the dividends to give to somebody else. If it's giving it to the father, fine, so it's giving it to another shareholder, but it's not giving it back to anybody. If you're giving it back, you'll be giving it to the company. And there's no justification to give it to the company that appears in this evidence. There's no reason to suppose, looking at the report, certainly of Mr. Sakroff, that the company is in any financial need, and certainly all the press clippings that were around at the time of the trial, all indicating this is a hugely successful group of companies. And so this is much more likely to be an internal political matter. And we say that's what the judge should very, very quickly have picked up.
So could you just take us the paragraph numbers in the judgment where you're saying the judge went wrong in this respect?
Yes.
Paragraph 101.
Sorry, back up on the screen.
Page 152 of the court.
Yes, I'm looking at 152, paragraph 100.
Did you start at paragraph 94? This is on page 151.
Certainly.
This is where the judge
Yes.
sets out for his finding that there's no financial value
Yes.
to the wife of her shareholding.
Yes.
And your submissions, as I understood it, were directed to that, to say that they plainly have had a financial value and that she's received dividends.
Yes, and my Lord, that's very precisely the point we made in our skeleton. That however you value a company, the benefit of the company to this wife cannot be put at zero merely because it is, in some sense, a non-marital asset. The value to the wife of this company can be amortised on the basis of £1 million income a year, if one were to amortise or average it out over the period of time. So to say it's of no value to her is wrong. It's just simply a wrong way of attributing a value in a valuable business, but attributing the wife's interest and value in it. So he says, as you say, in 94, I find no financial value in her shareholding. I recognise that on the face of it, 25% interest in a business worth, even on a net asset basis, some £400 million is very substantial. But for the reasons I've given, I do not regard this as an asset that is or will be available for the wife to realise. Well, that's with great respect to the learned judge, and that's simply not good enough. He before paragraph 94, he goes on to set this conclusion up. I think he probably starts at about in the mid-80s, devoting herself to the business. There's a strong possibility her rewards will increase. But the rewards don't increase without the shareholding and the fact that she's an employee. But even if she weren't an employee, one has to look at the family relationship and look at the mother's income, and it's the same thing. 86, not disagreeing with the evidence of the SJE company expert, shareholder company broadly the same rights the shareholder would have in England. Well, that is significant because you can't, as I said before, you can't just pay out a dividend and then call it back again, because by that stage it's the recipient's property. The evidence compels me to conclude the wife does indeed hold a share as a nominee for her father and subject to his discretion. That is,
Direction.
sorry, direction, beg your pardon. Yes, and maybe, but it's a shareholding. It's a shareholding that produces value, and the value is such as received by her. So in terms of value and in terms of a reasonable expectation of future profit and future income, and something, I mean, obviously it would be difficult to put those shares on the open market valued on the basis of dividends to date. That would be possible, but it would be difficult. But as within this family context, it must be a compelling argument that you have to look at the reality that this has generated for her £10 million, £9.5 million over 9 years. And you can't just ignore it. He then says the nominee shareholders are not a legal concept in Russian law, part of a widespread practice. Well, paragraph 89, he rather dismisses the whole idea. Not necessarily for me to go into whether or not they are matrimonial, but it's clear that any matrimonial element is minimal. Well, yes, if they're being held on behalf of him, but is she receiving the dividend income on his behalf? I don't think so. She's receiving the dividend income as being her rightful entitlement, as voted for by the general meeting, that this is her entitlement under her shareholding. And obviously her remuneration will be in some way affected or coloured by the payment of dividends as well. In other words, it's much easier to have a lower income, or more sensible, or makes it more understandable to have a lower income if you know that the dividends are going to average over £1 million a year. So in terms of the value of what she does, which is clearly very considerable, this is frankly illogical to say that, as the learned judge does. It's paragraph 92, negligible market for a minority interest in a family company where the other shareholders are all members of the family. Well, again, to her it's not. To her it's of great value, and she would be, the court's perfectly entitled to conclude that she would be able to pay, let's say, a lump sum, or let's say maintenance, if that were the issue, from what she could reasonably expect by way of ongoing dividends once these proceedings were over.
Well, then I think you'd say, looking at paragraph 97, no doubt that W will remain financially self-sufficient from time to time. Likely a dividend will be paid and should benefit. Nevertheless, without payment of dividend, should not be in a position to build up financial resources. A completely wrong approach. The judge should regard it as under section 25 as a foreseeable part of her income going forward.
Yes.
And that the treatment there is sort of like the quantum of the dividends is de minimis, it would just be a little top up, whereas you say this is a very substantial part of her remuneration, or at least her income.
I do, and I pray and aid the family relationship because it is a family company. The shares are owned within the family. The family is clearly very wealthy, even if one accepts the wife's own case that it's the mother who's been paying her all this money for the children. Question whether that's right or not, we don't know, and question whether or not we've got to the bottom of what funds the wife holds in Russia, because as you know, there have been continuing complaints about non-disclosure of Russian bank statements during the course of these proceedings, so we don't know. We know what we're told, and this appeal has to come to this court on the basis of what we've been told and what we know. And 99, you can see what she has received. And
what do you say about the finding at the end of 86? If somebody has a 25% shareholding in even a family company in this country, ordinarily you would say that there must be some prospect of selling up, and in the meantime there's a dividend income. But if the evidence compels the judge to conclude that the wife does hold her shares as nominee for her father and subject to his direction, doesn't it make it all rather more difficult?
Well, Lord, that's an area with respect in which we say the judge has simply got it wrong. If the wife wanted to realise the value in her shares, she could bring a Section 457 application or minority shareholder application
In Russia,
in Russia. And we're told by Mr. Saskov that the Russian provisions as to the ownership of shares is very similar to that in this country. I don't know whether it's Section 457 or anything else, but if that's what he tells us, and if I can't introduce my other evidence that does go to it, that's what we would say. There's nothing in Mr. Saskov's evidence or anybody else's evidence that suggests that the wife should be obliged to simply hand over all the value in these shares at the say-so of her father. She'd be entitled to say, well, hang on, I'm very grateful you've given them to me. I've given you very good service. You want me to just simply give them over without any consideration. I'm sorry, I'm not doing it. Sort of tinker and tinker type of situation, if you like. And if Russian law is similar to English law, why would that not be a valid argument on the part of the wife? The reason that it isn't is this is all a bit of a myth. It's all a bit of a fabrication, because the fact is that this is a family company, and the family not pleased with Mr. Xanthopoulos, and they are gathering around. We would say, it would appear from the evidence, they're gathering around to make sure he gets as little as possible, for obvious reasons. And that's where we are.
all right, well, where we are is 1 o'clock. Shall we break off at that point? 2 o'clock?